This section of the presentation covers the open meeting law's meeting notice requirements. Please note that this presentation is current as of March 2018. Please check with the Attorney General's office to ensure that a more recent presentation has not been published. You can do so by visiting the Attorney General's open meeting law website at www.mass.gov/AGO/open meeting. Except in an emergency, a public body must post notice of every meeting at least 48 hours in advance, not including Saturdays, Sundays, and legal holidays. So, for a Monday meeting, notice must be posted by the previous Thursday, assuming Monday is not a legal holiday. Each notice must include, at a minimum, the date, time, and place of the meeting, and a listing of topics that the chair reasonably anticipates will be discussed at the meeting. The topics must be described with enough detail so that a member of the public will understand what will be discussed at the meeting. Broad topics such as new business or old business are not sufficiently specific, though they may be used as headings under which more specific topics are listed. Public bodies may discuss topics that were not listed in a meeting notice if the topics were not reasonably anticipated by the chair 48 hours in advance of the meeting. Thus, public bodies may include a topic for public comment or open forum. However, our office strongly encourages public bodies to postpone taking action on any subject that arises for the first time during a meeting, particularly if the subject is controversial or of concern to members of the public, until appropriate notice of the discussion can be given to the public. Finally, notices must also include on the face of the notice or with the notice the date and time the notice was posted. This applies to any revised notice as well. Notices revised within 48 hours of a meeting must include the date and time that the original notice was posted and the date and time of the revision. This serves the dual purpose of letting the public know the body has complied with the law's posting requirements and assisting our office in resolving a complaint that alleges that the body failed to comply with the law. Public bodies do not have to post notice 48 hours before an emergency meeting. An emergency is a sudden, generally unexpected occurrence or set of circumstances demanding immediate action. An example of an emergency is a water main break or a flood, something that requires a public body to immediately take action and usually includes issues involving health or public safety. A forgotten deadline or scheduling conflicts among members generally will not constitute a valid basis for an emergency meeting. If a public body holds an emergency meeting, the public must post notice as soon as reasonably possible prior to that meeting. The next few slides cover how to post the notice for a meeting. Local public bodies must file a meeting notice with the municipal clerk. The notice must be posted in a manner conspicuously visible to the public, including persons with disabilities, at all hours in or on the municipal building where the clerk's office is located. Some towns use an outdoor bulletin board or a binder of notices in a weatherproof box to comply with this requirement. Alternatively, a municipality may adopt its website as the official location for notice posting. Prior to utilizing the municipal website, the chief executive officer of the municipality must authorize or vote to adopt such website as the official method of posting notice. The clerk of the municipality must inform the Division of Open Government of its notice posting method and must inform the division of any future changes to that posting method. Public bodies must consistently use the most current notice posting method on file with the division. A description of the website, including directions on how to locate notices on the website, must also be posted on or adjacent to the main and handicapped accessible entrances to the building where the clerk's office is located. If a municipal website is used, the clerk must still keep a paper copy of the notice available for the public to view during the clerk's regular business hours. Regional or district public bodies must post notice in each city or town within the region or district in the manner prescribed for local public bodies, or may post to a website as an alternative method of notice posting. Once again, any public body choosing to use an alternative posting method must inform the Division of Open Government. For a regional school district, the secretary of the regional school district is the clerk of the school district and shall file the notice with the clerk of each city or town in the district, or may post notice to a website as an alternative notice posting method. County public bodies must post notice with the office of the county commissioner, and a copy of the notice must be posted in a manner conspicuously visible to the public at all hours in a place or places designated by the county commissioners, or they may post to a website as an alternative notice posting method. State public bodies must post their meeting notices to a website. The website can be either the website of the public body or the website of its parent agency. State public bodies must notify the Attorney General of the location of the website where meeting notices will be posted, but do not have to send the Attorney General a copy of every notice. State public bodies do need to send a copy of each meeting notice to the Regulations Division of the Secretary of State's office. Notice can be sent by email to regs@sec.state.ma.us. There are some common concerns regarding notice posting. A question we frequently receive is, what do I do if a topic comes before the meeting, but after notice has been posted? Public bodies are encouraged to update the meeting notice if possible, if they become aware within the 48-hour period before the meeting of a new topic that will be discussed at the meeting. One way to prevent this problem is for chairs to avoid posting notices so far in advance that there is a high likelihood new topics will arise. Public bodies that wish to give the public additional notice of the dates it plans to meet may publish a schedule of all their meeting dates for a year. However, that schedule will not suffice as the open meeting law notice until the updated listing of topics is added closer to the time of the meeting. We are also frequently asked, what do I do if the clerk can't post notice in time? Chairs of local public bodies are encouraged to work with municipal clerks to enable sufficient time for posting. Responsibility for ensuring compliance with the open meeting law lies with the public body, not the clerk. It is therefore important to be familiar with the clerk's schedule. Some municipal clerks' offices are closed on Fridays or have reduced hours on certain days. A notice is considered posted when it is published to the public, not when it is received by the clerk. Meeting cancellations do not require 48 hours notice. They can be canceled at any time. However, we encourage public bodies to update the notice posting when a meeting is canceled. Meetings that are continued or canceled and rescheduled must comply with all notice requirements of the open meeting law. A public body cannot adjourn a meeting one night and then reconvene the next night unless 48 hours notice has been posted. Finally, it's important to note that other laws may require additional notice for certain meetings. For example, some public hearings require 2 weeks' notice and publication of the notice in a newspaper, in addition to the open meeting law's notice requirements. Notices should be easy to find on a website. Notices should be listed either in a central page where all notices are kept like a calendar page, or they should be listed on the public body's specific page. So, for example, the notice for a Board of Selectmen meeting would be listed on the page that is designated for the Board of Selectmen. It is best to avoid posting in multiple locations on a website unless they are all linked to the same document. Where a public body adopts a website as the official method of posting notices, it must make every effort to ensure that the website is accessible at all hours. If a website becomes inaccessible within 48 hours of a meeting, not including Saturdays, Sundays, or legal holidays, the website must be restored within 6 business hours of the discovery. If the website is not restored within 6 business hours, the public body must repost notice of its meeting to another date and time.